All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated. Good afternoon and welcome everyone to this initial appearance hearing. Madam Court Officer, could you please call the case?
Good afternoon, Your Honor. This is file KACBC 2023-12, the Specialist Prosecutor versus Hashim Thaçi, Bashkim Smakaj, Isni Kilaj, Fadil Fazliu, and Hayreddin Pucci.
Thank you, Madam Court Officer. Before we start, I would like to give the photographer the opportunity to make some pictures. Please proceed, Mr. Photographer. Thank you, Mr. Photographer. Before asking those present in the courtroom to introduce themselves, I would like to remind everyone of the rules that must be observed at all times in order to facilitate the smooth conduct of the proceedings. Please ensure that you activate your microphone before speaking and that you switch it off as soon as you are finished. Talk slowly and clearly, as we have interpretation from and into Albanian and Serbian. Wait 5 seconds before responding to me or a party in order to allow the interpreters to finish the interpretation. I would also like to remind you that certain information in this case is subject to confidentiality. Confidential information shall not be disclosed in open session. If any party wishes to refer to or discuss any confidential information, please request to go into private session. Now I would like to ask the parties to introduce themselves, starting with the Specialist Prosecutor's Office.
Good afternoon, Your Honor. Josh Hafetz on behalf of the Specialist Prosecutor's Office, and joining us here today are the Specialist Prosecutor Kim West, seated behind me, Earl Sullivan to my left, and Eleanor Corre behind him. Thank you.
Thank you. Now the defense, please.
Good afternoon, Your Honour. Ian Edwards from the Bar of England and Wales.
Thank you, Counsel. For the record, I note that your client, Mr. Kilaj, is also present in the courtroom. And I now turn to the registry, please.
Good afternoon, Your Honour, and good afternoon, colleagues. Jonas Nilsson, Deputy Registrar, and Whitney Price, Legal Counsel for Registry today.
Thank you. And last, for the record, Marjorie Masselot, pretrial judge for this case. The accused is appearing today for the first time before the specialist chambers, following confirmation of the indictment against him on 29th November 2024. Mr. Kilaj, would you please stand up? Could you please turn on your microphone and respond to the following questions? Could you please state your full name, date, and place of birth?
Isni Kilaj, born in Ljubišť, Mališev municipality, date of birth, 19th of December, 1963.
And could you also please indicate your citizenship or citizenships?
Kosovo citizenship.
Current profession, please.
Economist i diplomuar i pa punë.
An economist currently unemployed.
Thank you, Mr. Kilaj. Before we proceed any further, I have to make sure that you can follow the proceedings in a language that you understand and speak. Can you confirm that you understand and speak Albanian?
Po,
Yes, I do.
Mr. Kilaj, by this I'm satisfied that you can follow the proceedings in Albanian, a language that you understand and speak, in accordance with Rule 92 of the Rules of Procedure and Evidence. If at any moment in the course of the proceedings you are not receiving interpretation, please draw my attention to it immediately. Mr. Kilaj, you may now be seated and switch off your microphone. I will now give a short procedural history to introduce today's initial hearing. On 29th of November 2024, in my capacity as pretrial judge, I partially confirmed the indictment submitted by the specialist prosecutor against Mr. Thaçi, Bashkim Smakai, Hisni Kilaj, Fadil Fazliu, and Haredin Kuchi, charging Mr. Kilaj with one count of attempt to obstruct official persons in performing official duties by participating in the common action of a group, and one count of contempt of court. I also issued an arrest warrant for Mr. Kilaj on the same day. On the 5th of December 2024, the Specialist Prosecutor's Office arrested Mr. Kilaj in Kosovo, and he was served with the arrest warrant, the confirmed indictment, and the decision on his arrest warrant, translated into Albanian. On 6 December 2024, Mr. Kilaj was transferred to the detention facilities of the Kosovo Specialist Chambers in The Hague. That same day, I issued the decision setting today's date for the initial appearance. I recall that a request for rescheduling was actually granted, and this is why we are having this hearing today. Now, allow me to recall the specific purpose of this initial appearance for the benefit of Mr. Kilaj. Today's hearing, Mr. Kilaj, is not a trial. No evidence will be presented or debated, nor will your guilt or innocence be discussed or decided. The very purpose of this initial appearance hearing is regulated by Article 39.5 of the law and Rule 92 of the rules. According to these provisions, as a pretrial judge, I shall have the charges in the confirmed indictment read to the accused. Confirm that the accused understands the indictment. Satisfy myself that the rights of the accused, in particular his right to counsel, are respected. Inform the accused that within 30 days of today's hearing, he will be called upon to admit guilt or plead not guilty on each charge set out in the indictment. If the accused wishes to do so, he may also immediately admit guilt or plead not guilty. And finally, I shall set other dates as appropriate in performing my functions as pretrial judge. These are the matters which will be addressed in turn during today's initial appearance. Should either party wish to discuss any other matter not expressly foreseen in the context of the initial appearance, I invite you to do so through a filing in written form. First, Mr. Kilaj, may I invite you to please stand up. May I ask you to confirm that you have received the confirmed indictment in a language that you understand and speak? Please do not forget, yes, to turn on your microphone.
po.
Yes.
Kilaj. Before Madam Court Officer reads the confirmed charges against you, I wish to remind you that this is not the time to contest them, but simply to acknowledge your understanding thereof. You will have the opportunity to challenge the charges with the assistance of your counsel. I will now ask Madam Court Officer to read out the charges in the confirmed indictment as foreseen in Article 39.5 of the law and Rule 92.2b of the rules.
Thank you, Your Honor. 1. In the confirmed indictment, the Specialist Prosecutor charges Mr. Isni Kilaj with Count 14, attempting to obstruct official persons, in particular SPO prosecutors and investigators, in performing official duties by participating in the common action of a group punishable under Article 401(2) and 5 of the 2019 Kosovo Criminal Code and Article 15(2) of the law, and Count 15, contempt of court punishable under Article 393 of the 2019 Kosovo Criminal Code and Article 15(2) of the law. 2. These offences were committed between at least 6 October and 2 November 2023. 3. In relation to these offences, there is a well-grounded suspicion that Mr. Isni Kilaj is criminally responsible pursuant to Article 16.3 of the law for a. Committing the offence of attempted obstruction of official persons performing official duties under Count 14 pursuant to Article 17 of the 2019 Kosovo Criminal Code. b. Assisting Mr. Hashim Thaçi in the context of the group in the commission of the above of attempted obstruction of official persons performing official duties under Count 14 pursuant to Article 33 of the 2019 Kosovo Criminal Code. c. Assisting Mr. Hashim Thaçi in the commission of the offence of contempt of court under Count 15 pursuant to Article 33 of the 2019 Kosovo Criminal Code, and d. Agreeing to commit with Mr. Hashim Thaçi in the context of the group in the commission of the offence of attempted obstruction of official persons performing official duties under Count 14 pursuant to Article 35 of the 2019 Kosovo Criminal Code. Thank you, Your Honor.
Thank you, Madam Court Officer. Mr. Kilaj, did you understand the charges contained in the confirmed indictment as read to you by Madam Court Officer?
Po.
Yes.
The law on the specialist chambers and the rules of procedure and evidence guarantee you, Mr. Kilaj, a number of rights, and I will read out the most important ones, especially those relevant at this specific stage of the proceedings. You shall be presumed innocent until proven guilty beyond a reasonable doubt. In the determination of the charges against you, you are entitled to a fair and public hearing, subject to any measure ordered for the protection of victims and witnesses. You have the right to be informed promptly and in detail, in a language which you understand, of the nature and cause of the charges against you. You have the right to have adequate time and facilities for the preparation of your defense, and to communicate with the counsel of your own choosing. You have the right to be tried within a reasonable time. You have the right to be tried in your presence and to defend yourself through your counsel. You have the right to have counsel assigned to you and without payment if you do not have sufficient means to pay for it. You have the right to receive the free assistance of an interpreter if you cannot understand or speak the language used in court. You have the right not to be compelled to testify against yourself or to admit guilt. You have the right to remain silent, and no adverse inference shall be drawn from your silence. And you have the right not to be detained for an unreasonable period of time prior to the opening of the case, to request review of decisions on your detention, and to appeal such decisions directly before the Court of Appeals. Mr. Kilaj, I have read to you the most important rights that you enjoy in accordance to the applicable legal framework of the specialist chambers. Do you understand these rights?
Po.
Yes.
I also wish to inform you that according to Article 21(5) of the law, you may not represent yourself because you are currently in detention. Representation by specialist counsel is therefore mandatory. And I take note that you are represented by Counsel Edwards. And I'm therefore satisfied that the accused is presently represented by counsel. I will now turn to the right of the accused to enter an immediate plea, if any, in accordance with Rule 92 of the rules. Mr. Kilaj, within 30 days from today, you will be called upon to admit guilt or plead not guilty on the charges in the indictment. If you wish to do so, you may choose to immediately admit guilt or plead not guilty. I would therefore like to ask you, Mr. Kilaj, if you have had the opportunity to discuss the charges in the confirmed indictment with your counsel, and if you are prepared to enter a plea at this hearing.
Po.
Yes. I will enter a plea.
Right, please, you have the floor.
Deklarohem plotësisht I pafajshëm.
I plead absolutely not guilty.
This is on the record, Mr. Kilaj. And as you have chosen to plead not guilty on all counts, the pretrial proceedings will continue with a view to preparing this case for trial, pursuant to Rule 95 of the rules. You may be seated.
Thank you.
Let us now move to the working language of the proceedings. I recall that in the decision setting the date for today's initial appearance, I invited the parties to make oral submissions at today's hearing on the working language to be used in the prison case according to Rule 8 of the rules. Could the parties indicate their preference for the record, starting with the Specialist Prosecutor's Office?
We'll go with English again, Your Honor. Thank you.
This is well noted. For the defense?
Yes, English, please.
Thank you. I will issue a decision on this matter in due course. In said decision, I also indicated that I intend to schedule the first status conference in this case, pursuant to Rule 96 of the rules, on Tuesday, 17th of December, 2024, at 2 o'clock. I have also invited you to provide oral submissions at today's initial appearance on whether counsel and/or the accused intend to participate in this status conference in person or via video conference. You have the floor, Counsel Edwards, on this matter.
Yes, thank you, Your Honour. We will both attend in person.
Thank you, Counsel. I now turn to the Specialist Prosecutor as to your availability, reminding that you indeed already 4 times mentioned that you will be available, but for the record, I give you the floor.
For the 5th time, Your Honor, we're available and we'll be here.
Thank you. You will receive a scheduling order in due course that will also include the agenda. In that scheduling order, I will also provide guidance on the requirements for attending the status conference via video conference in case this becomes necessary. Now, in relation to Mr. Kilaj's detention, I recall, Mr. Kilaj, that based on the finding of a well-grounded suspicion that you committed the offenses that were just read to you, an arrest warrant was issued against you on 29th of November 2024. Pursuant to Article 41(6)(b) of the law, your arrest was found necessary based on the existence of articulable grounds to believe that you are a flight risk, you may obstruct the progress of the criminal proceedings, and you may repeat said offences. I also recall that you were served upon your arrest with my reasoned decision on request for arrest warrant and related matters, translated into Albanian, together with a confirmed indictment. Now I would like to know whether the defense wishes to make submissions on the issue of detention, and I therefore give you the floor, Counsel Edwards.
Your Honour, we certainly do want to make submissions on the question of detention.
So please, the floor is yours.
I wonder if I can start just by confirming that the interpreters have a copy of my speaking notes.
We do, Your Honor.
Can I just, on a personal note, thank you, Honour, for postponing today's hearing. It made travel over the weekend much more serene. Your Honour has found in confirming the indictment against Mr. Kilaj that there's a well-grounded suspicion that he's criminally responsible for the 2 counts that he faces. And so it stands to reason that the less onerous test of grounded suspicion required for ordering detention under Article 41(6) of the law is also met. And I can reassure Your Honour that I'm not going to spend time this afternoon by seeking to persuade Your Honour that you were wrong in arriving at your well-grounded suspicion finding. That's not the purpose of today's submissions. What I am going to do, however, is to focus on how this technical and rather legalistic difference between grounded and well-grounded suspicions does not, in reality, amount to such an appreciable difference in the mind of Mr. Kilaj, such that a risk that his behaviour now would change so dramatically from his proven behaviour over the last 7 months since he was released back in Kosovo. Your Honour, Mr. Kilaj has always been a good and safe candidate for conditional release. He was a good and safe candidate for conditional release 13 months ago, when we were last here in this room on the 4th of November 2023. I submitted then to the then single judge that Mr. Kilaj could be trusted with release, with conditions, notwithstanding the prosecution's objections based on an articulable ground or articulable grounds to believe that there was a risk of flight, a risk of obstructing the progress of proceedings, and the risk of committing further offences. Parenthetically, can I just say that although they are different, I think for the purposes of today's hearing, there may be common ground that the risks of committing offences is found on the same considerations as the risk of obstructing proceedings. So for brevity, I'm going to focus my submissions on just obstructing proceedings. In November of last year, the single judge was not prepared to give Mr. Kilaj the benefit of the doubt. And of course, in November of last year, Mr. Kilaj was something of an unknown quantity. He hadn't been tested. He hadn't been given the opportunity to show that he could be trusted with conditional release. And in the view of the single judge, the consequences of taking that chance with an unknown quantity was preferable, was more judicious, perhaps, was such that it was more judicious to order that Mr. Kilaj remain in custody. And that remained the case until the 3rd of May of this year. For reasons which, of course, Your Honour is very familiar, the single judge ruled that notwithstanding existing risks, it was no longer proportional or reasonable within the meaning of Rule 56.2 to extend Mr. Kilaj's detention. And that changed everything. Despite concrete concerns that Mr. Kilaj, if released, might abscond, that despite concrete concerns he might obstruct the proceedings, engage in interference, he was finally, after 6 months in detention, given a chance to prove that he could be trusted. He was given a chance to prove that earlier concerns and misgivings were simply misplaced. And indeed that they had been misplaced ever since November of 2023. And after his release in Kosovo, Mr. Kilaj repaid that trust. By his actions, he repaid that trust. Not just my words as his counsel, but by his actions, he showed that the single judge had been absolutely right to give him that chance. At footnote 78 of Your Honour's decision on request for arrest warrants and related matters of 29th of November 2024, you note that there is no information on record demonstrating that Mr. Kilaj did not comply with any of the conditions imposed on him. Well, that is perfectly true. But I would submit that we can put it far more positively. We can give Mr. Kilaj much more credit than that. All of the evidence on the record shows that he positively complied with the conditions of his release. Positively complied, faithfully, fully, to the letter, with every single one of the conditions, without fail, over the last 7 months. He lived and slept at the address notified to the specialist chambers every single day, without fail. He reported to his local police station once a week, without fail. I want to remain in public session, but I can tell you that he did nothing that he was prohibited from doing. He stayed within the territory of Kosovo, and Your Honour will recall that when he wanted to go away to Albania for just a few days with his wife, to have time away together in a place that was very dear to them, after the annus horribilis since November of 2023 that they had experienced. When he wanted to leave Kosovo, he did what he was expected to do. He did what he had been asked, what he had been ordered to do. He didn't just go to Albania recklessly, with a cavalier attitude. He asked first for Your Honour's authorization. And even though disappointed by your ruling, he respected Your Honour's decision. Now, I don't suggest that Mr. Kilaj deserves applause for having complied. He did what the court ordered him to do, as everyone should be, as everyone should do. So I don't ask for credit as such. But the reason why it's important, Your Honour, is that after 7 months, this court can now no longer say that Mr. Kilaj is an unknown quantity. It can no longer be said that he doesn't have a track record to which he can point. To say, look, when you put your trust in me, you know that I am deserving of that trust. I am worthy of the faith you put in me when you grant me bail. So that then now brings me to what the SPO says. They say that the situation now is totally different. It is totally different now to the situation as it was a week ago. And the situation is so different that one can put his record of compliance to one side, completely ignore it. And that the man who has proven his trust can now no longer be trusted. I submit that that is a quite unfair position to take. In reality, I ask rhetorically, how different is the situation now? Well, firstly, in relation to the suggestion that, there's the fact of the new fact of the confirmation of an indictment and the start of pretrial proceedings. I pause to say that these are not standalone factors. I suggest that one flows very much from the other. They're the same as the third factor pressed, that Mr. Kilaj now faces a much more concrete prospect of a lengthy term of imprisonment if convicted. In my submission, it would be wrong to look at these three things as quite separate. They're not. They all flow from the same thing. There's an indictment, he's in the pretrial stage, and he's facing a trial, and at the end of the trial, he's facing potentially a sentence. This is certainly a development, but it would be wrong in my submission to overstate the importance of this new development. Why? Because as far as Mr. Kilaj is concerned, there's nothing really that new. He's been aware from the very beginning of what evidence was found at and seized from his home on the 2nd of November last year. And I refer to the materials that are described in paragraph 22 of the public redacted version of the confirmed indictment. And since 15th of December last year, the date on which there was a first version of an indictment submitted for confirmation, that was also the date, coincidentally, of the SPO's first submission on review of detention, filing 538 of the 2018 case number. Since the 15th of December, Mr. Kilaj and his defence have been aware of what the SPO know of the 6th of October visit to Mr. Thaçi. The full transcript of that recording, the recording of that visit, was disclosed to us. And here, again, this is all public. I'm referring to paragraphs 20 to 21 in the confirmed indictment. Mr. Kilaj has known now for a year what the SPO say about the discussions relating to Witness 3 and Witness 4. So it's artificial, I submit, to make the distinction that the SPO press, the distinction that Mr. Kilaj may have thought in the past that there was a chance he would not face trial, but that risk has now become more concrete. No, that's not a reflection of the reality. Mr. Kilaj always knew that he was going to face trial. He has never harboured any doubt that the indictment against him would eventually be confirmed. And it was always obvious what sort of offences he would be tried for, even if the precise offence or offences and their precise modes of liability only recently became clarified. Mr. Kilaj always knew the nature of the sentences of which he was at risk, and always understood that they would involve potentially terms of imprisonment, even lengthy terms of imprisonment. This was never a mystery. The fact that this prospect may have become more concrete doesn't really change anything much at all. The prospect in his mind was always clear and present. He has pleaded not guilty to both charges in the indictment now. We're confident that we will demonstrate that he's not criminally responsible for anything. But at the risk of repeating myself, there has never been any doubt that there would be a trial. It's also worth highlighting, Your Honour, that every time the prosecution made submissions on the necessity of continuing detention from the 15th of December of last year, and again on the 12th of February of this year, and again on the 15th of April this year, the SPO pointed to factors that they said would only increase Mr. Kilaj's incentives to abscond or to obstruct the progress of proceedings. Whether that be the discovery of new evidence, or whether that be Mr. Kilaj's knowledge of an indictment or a revised indictment being submitted for confirmation. That's all part of the SPO's playbook, if I can put it that way. Now, of course, as time passes, developments in a case occur, and especially when the investigation continues whilst a suspect is in prison, in detention. Now, that's inevitable. But what the SPO has inevitably instrumentalized is these developments, this drip feed of, well, there's this new evidence that we're telling you about now, or there's this new factor of the indictment being submitted for confirmation. The SPO have always instrumentalized these developments in order to argue that they buttress the reasons for maintaining Mr. Kilaj in detention. So, between November of 2023 and May of this year, the SPO argued that the risks of flight and the risks of obstruction were getting stronger and stronger and becoming more and more likely, and therefore that Mr. Kilaj's incentives to abscond or to obstruct were getting stronger and stronger. And yet, once he was given that chance, once he was released on bail, once he was put to the test, those concerns evaporated away. They ought to have evaporated away. The fears of the SPO, the fears of the single judge, it turned out, never materialized. He did not abscond. He did not interfere. He didn't do anything to obstruct proceedings. He kept himself to himself, at home, with his family, living his life, getting on with it, complying faithfully and completely with all conditions. But now the SPO say, well, there's a confirmed indictment, and the risks are now sufficiently great that revoking bail is the only solution, that it is now justifiable to ignore his demonstrated willingness to comply with release conditions. And it's that I'd like to explore for a moment. In concrete terms, what has changed is this. Whereas before there was, in inverted commas, only grounded suspicion of Mr. Kilaj's criminal responsibility, as defined under Article 19(1)(9) of the Kosovan Criminal Procedure Code. Well, now there is a well-grounded suspicion, as defined under Article 19(1)(12). Now, I'm not going to argue that the threshold for a well-grounded suspicion is not higher. Of course it is. But what is absurd, what is artificial in my submission, is the suggestion that Mr. Kilaj would not abscond, would not interfere in circumstances where a hypothetical, objective observer would be satisfied he was more likely guilty than not, the test for grounded suspicion. Or in other words, probably guilty, 51% or more guilty, based on that hypothetical person having knowledge of information. But now we move into the realm of well-grounded suspicion of guilt. Suddenly, the SPO suggests that he would suddenly have this incentive. Suddenly this incentive would blossom, an incentive to abscond or interfere, that some sort of switch is flicked in his mind, moving from one threshold to a higher threshold, now based on possession of admissible evidence that leads an objective observer, or in concrete terms, in fact, Your Honour yourself, to be satisfied that he's guilty, to a standard somewhere between 51%, more likely than not, and the criminal standard of beyond reasonable doubt or intimate conviction. Now, these are interesting, these are important distinctions for lawyers, perhaps. But in my submission, it's quite unrealistic to think that it is such a huge difference to a non-lawyer like Mr. Kilaj that it would so significantly operate on his mind so that he would suddenly now decide to take the huge risk of absconding from Kosovo. What does that mean in reality for a husband, a father, a grandfather of nearly 60 years old? That this difference between grounded suspicion and well-grounded suspicion is such that he would take the risk of turning his life upside down, go into hiding for the rest of his life, become a fugitive from justice for the rest of his life, to forfeit an enormous sum of money paid in by way of a security, to uproot himself from his wife, from his family, from his community, everything that he has built over his life, everything that he knows, or perhaps try to persuade his wife to go with him and separate herself from their family, to throw all that away. That's what the SPO is asking you to accept. The SPO will cite, no doubt, to jurisprudence from this court and the ICTY and other courts, and try to persuade you that this distinction, this threshold that changes once an indictment is confirmed, is as important as they say it is. But I ask you to look below the surface of that jurisprudence and ask yourself, what is that actually going to mean to a man like Mr. Kilaj? The prosecutions say that because now the threshold of well-grounded suspicion has been reached, that now you think he's guilty to a higher standard, somewhere between the common law, the civil standard, 51%, and somewhere between that and beyond reasonable doubt. We suggest that that's quite unrealistic. And similarly, it's unrealistic to think that it would make such a difference so as to operate on Mr. Kilaj's mind, and now make him decide that, okay, even if he doesn't abscond, that now he would take the risk of obstructing the proceedings by, I don't know, contacting a witness or seeking to hide evidence or destroy evidence, when you know that he has had the means and every opportunity to do exactly that, if that was what he intended to do, at any time over the last 7 months. But he didn't. Forgive me for the informality of my language, but come on, really? It's the prosecution's position, what they're asking you to accept, is absurd. It's nonsense. This cannot be the hook on which Your Honour hangs a decision to remove the liberty of a man who has peacefully enjoyed conditional release over the last 7 months, because it's an insubstantial, it's a rusty old hook that is half falling out of a crumbling wall. Mr. Kilaj always knew that this indictment was coming. It was inevitable. The SPO says, however, it changes everything, and that justifies locking him up now. The prosecution have leapt on this so-called new development in order to try and persuade you to keep Mr. Kilaj in prison. It's what they've always wanted. They were not happy when your predecessor granted Mr. Kilaj provisional release. They filed a hopeless appeal. But the importance of that change is, we submit, illusory. Don't attach any weight to it, Your Honour. I would respectfully submit. What else? Your Honour, in the decision, referred to the fact that Mr. Kilaj is now aware of the gravity of the specific offences with which he is now charged, and which go beyond what he initially foresaw. I'm afraid to say that that is simply factually incorrect. Why do I say that? Mr. Kilaj always knew that he was in jeopardy of a sentence on conviction of up to 5 years under the aggravated form of Article 401(5). Your Honour, I've made copies, and I've made copies also for the prosecution. I wonder if I could pass up to you a couple of documents.
Would you provide copies also for the SPO?
Yes, of course.
Yes, of course.
For Her Honour and for the SPO, please. Thank you. Yep, there are 2 documents annotated with a J in the top right-hand corner for Her Honour, and 2 annotated with S for the prosecution.
Yes, this. It's fine.
Thank you.
Maybe just for the record, can you just present those 2
Yes.
documents, which are part of the record of this case?
They certainly are. The first is the prosecution's first request for continued detention. It's filing 496 of 3rd November 2023. And could I invite Your Honour to turn to paragraph 16 of that filing. And the SPO says this: Kilaj is aware that evidence potentially supporting grave charges, which could attract a term of imprisonment of up to 5 years, have been seized from his residence. And then the next day, 4th of November of last year, during Mr. Kilaj's first appearance, the prosecution said this in open session at transcript page 174. I've highlighted it on Your Honour's copy. Mr. Kilaj is a flight risk. He's facing serious allegations of criminal conduct with offences carrying sentences of up to 5 years. He has clear incentives to flee the court's jurisdiction, including to third states where a request for extradition may not be accepted. This argument was acknowledged by the single judge in his decision, his first detention decision, and his reasons for that detention decision of 9th November 2023. This is filing 503 at paragraph 36. And it's that decision that forms the foundation for every other one of his subsequent detention extension decisions. And I add that the SPO has never made a secret of the fact that the official persons performing official duties of relevance to Mr. Kilaj's Article 401 allegation were investigators, prosecutors, court officials of this court. I ask rhetorically, who else would it be? Who else? What other official persons could he be charged with trying to obstruct? Mr. Kilaj has always known that the aggravated form of Article 401 under Subarticle 5 was envisaged by the SPO and the single judge, that 5 years was on the card. So to say that this goes beyond what he initially foresaw, therefore, is, I'm afraid, simply not correct. But the reality goes even further. Since the confirmation of the indictment against him, Mr. Kilaj now knows exactly of what he is in jeopardy. And the reality is that he's facing offences that carry a lesser sentence than what he initially foresaw. He's charged with attempt and with assistance as a mode of liability under Article 33. Article 33 provides that a person assisting shall be punished more leniently than the direct perpetrator of an offence. So right away we see that the maximum of 5 years cannot reasonably be available to the trial panel, even if Mr. Kilaj is convicted. And the same goes if he was convicted of agreeing to assist under Article 35. Furthermore, even if Mr. Kilaj is aware that these offences can carry sentences of imprisonment, even reasonably lengthy sentences of imprisonment, his awareness of the sentences handed down to Messrs. Thaçi and Haradinaj, that Your Honour made reference to, only go to serve that he is looking at significantly less of a sentence than the 4 years and 3 months that they received. Thaçi and Haradinaj were convicted of 5 counts, including much more serious offences of obstructing by way of serious threats under Article 401(1), as leaders or organisers of groups under Article 401(3), with intimidation under Article 387, and under the aggravating versions of violating the secrecy of proceedings under Article 392. That's why they got 4 years and 3 months. In a completely different class of situation to Mr. Kilaj. They're all so much more serious than the offences with which Mr. Kilaj now knows he is charged. And indeed, I'd go further. The second of the 2 counts with which he is now charged, contempt, under Article 393, is less serious than the second count of violating the secrecy of proceedings, which is what he was originally suspected of. Article 393, contempt, that carries a maximum of 6 months. It's a less serious charge than what he was earlier facing. And of course, under the aggravated form of Article 392, that carries a maximum of 5 years. Plus the fact he's already served 6 months, and that would be taken into account, wouldn't it? So to summarize, Your Honor, what he is charged with in the confirmed indictment has provided clarity and certainty that he is in less jeopardy now than what was initially believed, with likely shorter sentences of imprisonment. This does not provide a more concrete incentive to abscond, as the prosecution suggests. He may always have had that incentive, but the confirmation decision does not, in real terms, change anything. On the contrary, Mr. Kilaj should benefit from his proven demonstration that even though he may have had an incentive or motive and means and opportunity since his release, he has not in fact absconded. He has not interfered. He has not obstructed. It was previously found that his knowledge of the existence of an indictment against him and the prospect of facing criminal charges made the risks of his obstructing proceedings particularly high. And yet he was released, and those risks never materialized. And I submit that this is an extremely important factor to take fully into account. This is not a factor that can just cheerfully be swept under the rug. Because the SPO keeps banging the same drum, keeps playing the same broken record, and argues that he's a man who cannot be trusted because there's evidence demonstrating his willingness to misuse Specialist Chambers information, and that, to use their rather emotive terminology, he has demonstrated a wanton disregard for confidentiality rules. So his past disregard for SPO rules, that can be placed in the scales by the prosecution, sure. I then place on the defense side of the scales the fact that for the last 7 months he has complied with Specialist Chambers rules. He has shown a perfect willingness and a perfect ability to fully comply with the rules. He hasn't put a foot wrong. If there was a hint that he had obstructed anything at all, obstructed the process, if he'd done anything wrong, if he'd tried to interfere in any way at all, I suggest you would have known about it. You can and you must, I would submit, Your Honour, weigh in the scales that more recent behaviour of compliance, because I suggest that it provides, it goes a long way to counterbalancing anything the SPO say about his disregard for rules in the past. The fact that he was given the chance and the fact that he has complied so faithfully is something that I would suggest this institution should be encouraged by, should be pleased to see. Very briefly, I would submit it can't be ignored that what he's actually charged with in the confirmed indictment is not actually directly obstructing. He may be charged with attempt, with assisting, with conspiracy, with agreement, but not actually obstructing himself. Had there been any evidence that he had obstructed over the last 7 months, you'd know about it. And there simply is no basis to believe that the situation has changed now, that suddenly there are greater risks simply because the indictment has been confirmed and that he's now facing trial. Your Honour may be of the view, in fact in Your Honour's decision you said that compliance with the rules in the past does not equate to the elimination of risk. Well, I agree, of course. But, Your Honour, risk can never be entirely eliminated when a person is on conditional release. The single judge, when granting him release, acknowledged that there's always a risk. But really the question is, are you prepared to put some trust in Mr. Kilaj? The single judge was, and that trust was rewarded. As far as the suggestion that he may tamper or hide any evidence, it is also rather curious. The prosecution does not say that he has tampered with evidence or hidden any evidence since granted bail. The prosecution don't even suggest what evidence is at risk of being tampered with or being hidden, because there is none. The prosecution have it all. I don't ask Your Honour to place your trust to give Mr. Kilaj a chance unconditionally. I urge you to find that he is a good candidate for bail and to impose precisely the same conditions that were imposed by the single judge back in May and with which Mr. Kilaj has fully complied. Indeed, it's open to Your Honour, of course, to impose further conditions if Your Honour were to be of the view that developments over the last couple of weeks have made a difference. You may order Mr. Kilaj to report to his local police station more than once a week. You may order Mr. Kilaj not to travel beyond a certain radius of his home in Malasheva, for example. You may even order Mr. Kilaj not to use any communication device other than to communicate with his counsel, although you may think that that's unduly onerous and, frankly, not very practical. What I can tell Your Honours, having spoken with Mr. Kilaj's family, is that they can increase the financial security to pay into court from 30,000 euros to 40,000 euros. It won't be easy. Mr. Kilaj is not a rich man. His family is not a rich family. But the family and the extended family are prepared to dig deep, to make sacrifices, to scrape together such an enormous amount of money. They're willing to make those sacrifices because they trust Mr. Kilaj. Knowledge on the part of Mr. Kilaj that such a huge amount of money would be lost if he were to abscond, or indeed to be found to have obstructed the proceedings. Knowledge of such a loss would act as a huge disincentive on Mr. Kilaj, now going forward, just as it has done in the past. And I'd like to end on this point, Your Honour. It was always envisaged by the single judge that Mr. Kilaj could keep his liberty after confirmation of the indictment. That was envisaged, and that's why the condition was imposed on him to attend any future hearing required by the court and to inform the registrar of any address in the host state. Your Honour, had he been given the opportunity to travel to the Netherlands to appear before you pursuant to a summons, he would have done. Had you given him the chance to prove his willingness to do what he was ordered to do, he would have done it, and he would have done it cheerfully. He wasn't given that chance, as it turns out, and the events of the last few days have shaken him. They've shaken his family. He and everyone in his family were always resigned to the fact that there would be a trial. They're prepared for that, and they're more than prepared to allow the wheels of justice to turn. But what was, frankly, rather unexpected, is that he would be arrested, that his conditional release would be revoked, and that he would be maintained in detention whilst waiting for that trial. He's horrified by the prospect of spending a second birthday next week locked up, a second Christmas, a second New Year away from his family. The last few days back in The Hague, in detention, have been a horrible reminder of him, what would happen if he were to put a foot wrong in the future. But since May, he never has put a foot wrong. He was given that chance. He proved he was worthy of that trust. And we simply ask you to give him that chance again, to trust him, because he's deserving of it. Your Honour, those are my submissions, unless you have any questions for me.
I have no question at a specific moment. Thank you, Counsel, and I will give the floor to the Specialist Prosecutor.
Thank you, Your Honor. I'm going to just briefly respond to a few of the points that counsel has made. The ground truth is that Mr. Kilaj, as he sits here today, based on the quantum of proof that's been gathered already and the charges that Your Honor has confirmed, the ground truth is he presents a clear and present danger to the functioning of this institution. I'm not going to elaborate on every finding Your Honor made. I don't think we need to do that. Paragraphs 56 through 68 of Your Honor's decision in F0037 are well-reasoned, they're well-articulated, and they're supported by the facts. Nearly everything that counsel just articulated is covered by, articulated by, and disposed of in Your Honor's decision. So I'm not going to go on at length unless Your Honor has specific points that you believe should be clarified for you before we move on. But a couple of things to point out. The repeated assertion, something like over 10 times just now, that Mr. Kilaj has known, or in his subjective mind has been expecting, or whatever the mental formulation of it is, has known that there would be these charges against him, is just meaningless for what we're talking about today. Until now, there have been no confirmed charges. We stand here today in a place that has rules. And the rule is, Your Honor, or a pretrial judge, must confirm a charge before it becomes a charge. So if we remember back to November of 2023, when Mr. Kilaj was arrested and stood here in this room and was represented by Mr. Edwards, saying that none of the evidence the SPO was presenting then merited his detention or merited any charges because they were all innocent explanations. Well, he couldn't possibly have known he was going to be charged then because, as in his mind, there was nothing to charge, did nothing wrong. We're in a different place now, legally and practically. He knows there are significant charges against him. He knows he now faces confirmed charges of detention. That's the operative fact. The other point I want to just make clear, and Your Honor has already dealt with this, but just to emphasize, Mr. Kilaj wasn't released on the idea that he could be trusted or should be given a chance to be trusted. He was released, over our objection, that's correct, he was released because of the delay in the proceedings and because of the proportionality issue of how long he might foreseeably be detained prior to trial. That's gone. We're in a different state now. Your Honor has confirmed charges against him, and we're on the road to getting Mr. Kilaj and his co-accused a trial. We agree that trial should be swift. That's the goal. That's what the rules are for and what they dictate and necessitate. But that was the only reason he was released. That's gone now. It wasn't to give him a chance. It wasn't to be nice. That's the reason. And that reason, as Your Honor points out in her decision, has been removed. Mr. Kilaj has demonstrated, not our words, but now Your Honor's words in the decision, a wanton disregard for the rules of this institution. That has grown significantly since he last stood here, not addressed by counsel, and that's all right. But Mr. Kilaj's possession of material of confidential witness-related material in this case is frankly staggering. He cannot be trusted out on his own, alone, with the new material he's going to get and with the material he already had. He cannot be. The concept that was noted several times about there is confusion, apparent confusion about why anyone would suggest the SPO or in Your Honor's decision that Mr. Kilaj poses a risk of future obstruction is somewhat belied by the fact that when the SPO searched his house, there was a trash bag full of torn up SPO confidential witness statement in the bag, which is noted in our filings. Mr. Kilaj presents a clear risk of flight, a clear risk of obstruction in these proceedings, and I submit he presents a danger still to other ongoing proceedings in this institution, which is backed up by the quantum of evidence that has been recovered from him already, which shows not just that he previously attempted to obstruct with proceedings here, but that he has zero regard for this place's rules, its regulations, or its desire and mandate to function under the law. None. So, Your Honor, I have nothing else to add now other than any questions you have. But to be clear, your decision has already dealt with this effectively, and the submissions we've made make clear that under all three factors, not one, not two of them, all three of them, Mr. Kilaj's detention is necessary. Thank you.
Thank you, Mr. Prosecutor. Does the defense want to take the floor?
Extremely briefly. Yes, Your Honour has made a decision. Yes, Your Honour has found that, that there are reasons to maintain Mr. Kilaj in custody. But you made that decision without having had the benefit of defence submissions on the point. And that's why we're here. My learned friend suggests that when Mr. Kilaj stood here in November of last year, he said, there's an innocent explanation for why I have what I have, and that would have been a reason for him to think that there would be no trial. That's complete nonsense. A defendant who is arrested and brought to court may well say at his first appearance, well, I hit the man in self-defense, or I didn't intend to permanently deprive the person of the thing I'm accused of stealing. A person may say in court, I have a defense. That doesn't mean there's not going to be a trial. And thirdly, my learned friend, again, returns to the leitmotif that, that Mr. Kilaj cannot be trusted because he was in possession of so much confidential material. What he is not charged with, because they cannot charge him with it, is that he then did anything with it. Please don't forget that, Your Honour. He may have been in possession of evidence that he wasn't entitled to, but if it just sits there on a computer and doesn't go anywhere, you have to take that into account when deciding how dangerous Mr. Kilaj is. That's all I had to say in response.
Thank you, Counsel. We will have a break, of course, during which I will consider those submissions and I will issue the decision, an oral order on this issue today. Before that, I would like to know if there is any other issue that the parties would like to raise.
I don't know if it's crossed Your Honour's desk, but I can tell you that just yesterday I filed a withdrawal. I'm just trying to a withdrawal of my application for a date for the confirmation, or a target date for the confirmation. In the circumstances, that is now an entirely moot motion, and it has been formally withdrawn. Filing 805 under the 2018 case file.
This is well noted. If there is no other issue that the parties may wish to raise, we will now take a break, I would say of an hour. So it is 2:15, and we will reconvene at 3:20.
All rise. All rise.
Please be seated. So we are now back in session, and I note for the record that all parties and the registry's representatives are back in courtroom. I will now issue my oral ruling on Mr. Kilaj's detention. Counsel Edwards, I have taken note of your request for Mr. Kilaj's release on conditions as those set forth in the decision KSC BC 2018-1 F658 Core, dated 3rd of May 2024, and any other additional condition. I take note of your submission regarding Mr. Kilaj's proven behavior over the last 7 months, that he can be trusted and that he positively and faithfully complied with all conditions imposed. You underline that Mr. Kilaj has not fled, has not obstructed, and has not repeated the offences while on conditional release. I also take note of your claim that the confirmation of the indictment and the start of pretrial proceedings do not change Mr. Kilaj's situation. As to the existence of the 3 risks under Article 41(6)(b) of the law, you submit at the outset that Mr. Kilaj has known for a year about the SPO's factual and legal allegations now contained in the confirmed indictment, and the potential lengthy sentence emanating therefrom. You emphasize in particular that the establishment of well-grounded suspicion at this stage does not incentivize Mr. Kilaj to flee. You also argue that Mr. Kilaj would likely not take the risk of obstructing the proceedings by, for example, contacting a witness or seeking to hide evidence or destroy evidence, given that he has had the means and every opportunity to do exactly that at any time over the last 7 months. In this context, you also underline that even so Mr. Kilaj may have been in possession of confidential material, he has never used it. You further argue that Mr. Kilaj has pleaded not guilty and is fully aware that a trial will ensue. You also request that I consider that Mr. Kilaj is not charged for obstructing directly, and that whereas case-related material was disclosed to Mr. Kilaj when in detention this year, the 3 risks never materialized. I've taken note of the specialist prosecutor's position that Mr. Kilaj's request for conditional release be denied and that he remain in detention. The SPO argues that all three risks exist. In the SPO's view, Mr. Kilaj presents a clear and present danger to the functioning of the specialist chambers. The SPO stresses that the circumstances change since 1. The indictment has been confirmed only on 29 November 2024, while Mr. Kilaj did not know of the charges at the time of his detention and conditional release. 2. Mr. Kilaj was released on the basis of proportionality considerations following undue delay in the investigation, which is no longer the case today. And 3. Mr. Kilaj was in possession of confidential material and will continue to receive further such material. Having considered all arguments, I find that none of your arguments, defense counsel, are capable of changing my assessment that the conditions provided in Article 41(6) of the law are met, as set out in the decision on arrest warrants and related matters, filing F37, paragraphs 43 and 56 to 67. Specifically, I'm not persuaded that Mr. Kilaj is not a flight risk, mindful of his past compliance with the conditions imposed. For the reasons set out in paragraph 56 to 60 in the decision on arrest warrant and related matters, I remain convinced that there is a risk of flight. Contrary to the arguments of the defense, the confirmed indictment now subjects Mr. Kilaj to concrete charges. Accordingly, he will also receive progressively the entirety of the evidence in this case, which gives him additional incentive to flee. The fact that Mr. Kilaj has rooted family ties in Kosovo only partially mitigates and does not diminish the risk. As to the risks of obstructing criminal proceedings and repeating offences, I make reference to my findings in paragraph 61 to 66 of the decision on arrest warrants and related matters, and find that these risks continue to exist for the same reasons as I just outlined in relation to the flight risk. Therefore, having considered the parties' submissions, I determine that Mr. Kilaj shall remain in detention. The reasons for your detention, Mr. Kilaj, are the same as set out in the decision on arrest warrant and related matters at paragraphs 43 and 56 to 67, which shall be read together with the present ruling. Accordingly, based on the information and material underpinning decision F37, and in the absence of any contrary intervening information or development, I find that, first, there is a well-grounded suspicion that you are criminally responsible for the offences of which you were informed today. And second, there are articulable grounds to believe that you are a flight risk, you will obstruct the progress of the criminal proceedings, and you will repeat the criminal offences. Furthermore, neither the conditions you propose, Counsel Edwards, such as bail in the amount of 40,000 euros, frequent reporting to the Kosovo police, and restrictions on communications and movement, nor any other conditions I may impose on Mr. Kilaj are capable or adequate to mitigate these risks. Lastly, I find that Mr. Kilaj's detention is proportionate, notwithstanding his past detention from 2nd of November 2023 to 15th of May 2024, in light of the possible sentence faced in the event of conviction and the progress of the proceedings. Mr. Kilaj, I will review for your detention, the reasons for your detention within 2 months or at an earlier time upon request or a change in circumstances as provided in Article 41(10) of the law and Rule 57(2) of the rules. Counsel Edwards, should you wish to file submissions on the next review of detention, please do so by no later than Wednesday, 15th of January 2025. Responses and replies will follow the timeline set out in Rule 76 of the rules. Should the defense decide not to file any submissions by the aforementioned time limit, I order the SPO to file submissions on the review of Mr. Kilaj's detention by no later than Tuesday, 21st of January 2025. The defense shall then respond, if it so wishes, by no later than Tuesday, 28th of January 2025, and I will not entertain a reply. Lastly, Mr. Kilaj, you have the right to appeal today's ruling on your detention directly before the Court of Appeal within 10 days, as provided in Article 45(2) of the Law and Rules 58 and 170 of the rules. This concludes my oral hearing, and this concludes also today's hearing. I wish to thank all the parties for their participation in the attendance and participation to this hearing, as well as all those who made this hearing possible today.
All rise.
The hearing is adjourned.